Hello everybody, I'm George from Ireland, so welcome back to the English Law channel. I'm carrying on with freehold covenants, so now I'm going to examine the discharge and modification of freehold covenants. Now, in some narrow situations, a court could decline to enforce a restrictive covenant. For instance, where the person entitled to enforce it has not taken action for a long time despite flagrant breaches, or if the character of the area has changed majorly. So in Chatsworth Estates against Fuel, 1931, for instance, it was said that the benefit of the covenant had been abandoned because the covenantees had taken no action despite very blatant breaches by others in the area. They took action only against one defendant, and on the facts the court said there's been no abandonment despite the argument, but the argument could be valid, but in this particular case it wasn't. In Shaw and Applegate, 1977, it was found the covenanter in breach of the covenant had been lulled into false sense of security. That's a quotation from the judge, because the covenantee had taken such a long time to enforce the covenant, so the court declined to grant an injunction and instead awarded damages. So the remedy was pecuniarily awarded. So remember what equity says, you must not sleep on your rights, you must take prompt action. Further, the LPA 1925 gives the Lands Tribunal the discretionary power to alter or discharge a restrictive covenant with granting compensation or without granting compensation as they may see fit. And it says these are the criteria to be examined in deciding what to do. So a covenant could be discharged or modified in view of the following criteria. 1, it is deemed obsolete due to changes in that area. 2, it obstructs the reasonable usage of land, and provided that monetary compensation is sufficient, either the covenant provides no practical benefits of substantial benefit or advantage, or indeed it could be against the public interest. 3, the parties agree so, either expressly or impliedly. And 4, it will not harm anyone entitled to a benefit. So generally speaking, the tribunal has taken a narrow view in its exercise of powers, is reluctant to change things. Specifically, is refused to order modification and discharge a restrictive covenant simply on the basis that planning permission has been gained for another user, even though the extension of planning control under the main planning statute, the Town and Country Planning Act 1971, or its 1990 iteration, has reduced the role of private planning. That's where freehold and leasehold covenants play a key role now. Play less of a key role now. So these two systems continue to operate in parallel. Now let's look at reform to the system. Well, on the 8th of June 2011, the Law Commission published a report, their 327th one, and it was called Making Land Work. It was about easements, covenants, profits à prendre. So the report included some sweeping suggestions about the law of non-leasehold covenants. The Commission suggested that they should change the law with a new land obligation, and that would permit the enforcement of both positive and negative obligations by and against successors entitled to land. The Commission foresaw such land obligations being created expressly by deed, and they could enter into on both affected registered titles. Their proposition was that when the original parties had parted with the land, they would no longer be liable for breaches that happened afterwards. So the proposals met with broad approbation. But somebody called O'Connor, an academic, argued against it. You could see his article, Careful What You Wish For Positive Freehold Covenants. So on the 18th of May 2016, Her Majesty's Government announced it wanted to implement some aspects of the Law Commission's recommendations, but to date it hasn't put forward a bill. I don't think there's been a white paper or a green paper either, these sort of discussion documents through various stages. Okay, so that's enough about freehold covenants. Toodaloo.